So good morning, everybody. My name is Paul Horn, and thank you for joining our class this morning. Um, let's see here, and I'm assuming that I think you guys can all hear me okay, right? So as I'm covering these material, if you have any question, you can raise your hand and I will unmute you, okay? Yeah, so as we progress this in class, raise your hand and I will come in and unmute you. Oh, let's see here. All right. Yeah, so just raise your hand and I'll unmute you. Okay, so let us start. So this class, what is this class all about? This class is all about your seller have passed away. Okay. So if all of you kind of remember the short sale day, there was a lot of short sale. Well, I think the next wave of baby boomer passing away. So you're going to see a lot of deceased individual who pass away. You're going to receive a phone call from a son or daughter that says, hey, my mom passed away, my dad passed away. Can you sell this house? And when you get that phone call, what would you do? Right? Would you know the roadmap? Would you have kind of a understanding of when you can list this house, when you can sell this house, and who is your seller? Because your true seller, mom, she's in heaven. So unless you are able to go to heaven to get mom to sign your listing agreement, who is the next best person? Mom has 4 children. Which of the 4 will you choose to sign your listing agreement, right? So that is the main topic of this class. The other topic we're going to talk about is taxes. You yourself bought a house for 200,000, 300,000, and now it's worth $1 million, it's worth $2 million. When you pass away, the house that you bought for 200,000 is worth $2 million. Your children sells for $2 million. Are there any capital gain? Okay, so that's a question that you should want to understand, right? When I give my house to my kid, do they need to pay any taxes? So that's an important topic we will cover as well. Okay, so let us begin. And so remember, if you have any questions, just raise your hand and I will unmute you, okay? All right, so, and I trust that you are able to see my screen okay, right, guys? You can see my PowerPoint okay? All right, let us begin. So, I'm a probate attorney. All I do is probate. All I do is estate planning, living trust, okay? So, when you receive a phone call, hey, mom passed away, sell this house, the first thing you ought to do is pull the grandee. Okay, just pull the grandee. When you pull the grandee, it's going to tell you who owns this house. When you pull the grandee, and if the house is in a trust, hallelujah, right? No probate needed. You can move forward in your escrow transaction. So, mom passed away. You pull the grandee. The house is in the trust. Mom has 4 children. So who signs your listing agreement? Well, that would be the successor trustee. Okay, the successor trustee named in the trust. Okay, you should probably take out your Kodak phone. This is a Kodak moment and take a picture of this screen. It says, hey, who has the right to sign your trust listing agreement? The house is in the trust. There are 4 children. We don't necessarily need to worry about the other 3 in terms of who has the legal authority to sign your listing agreement. It's going to be the successor trustee. Now, how would you confirm that Sarah or John or Henry is the successor trustee? Well, you need to see a copy of the trust. Okay, so normally the children will give you a copy of the trust. Normally, they'll give you a copy of the trust. And when you get it, when you read through it, you'll see the word successor trustee as you see on the screen. Now, so the children will search the file cabinet, the safe box, a lock box, home offices, personal drawer, okay? Or maybe even contact the estate planning attorney. Now, so locate the trust, and normally the children will give you a copy of the trust. Normally they will know where it is, okay? So my question to you, what happened if they cannot find this binder? Normally the trust is in this binder. What happened if they cannot find the estate planning document? Well, then it goes to probate. So let me repeat that. You created a trust. You die, and you will die, right? You die, and they cannot find this binder, this estate planning binder. The trust is lost. The house is in the trust per the grantee, but your children are unable to locate the trust. What then? Well, too bad, so sad. Welcome to probate. Okay, so first important lesson. If you have a trust, you better make a copy of it, a PDF copy of it. A copy is just as good as the original. If you lose a trust, even though the house is in a trust and there's no copy of a trust, it's just as if you have no trust, no estate planning. Okay? Raise your hand if you have any question about this, and I will unmute you. Okay, so a very important point at this moment. All right, let's say hi to Angela. Let's see, Angela, are you, let me see if I can, let's see. Hi, Angela, can you say something? Hi, Angela.
Hi, good morning, Mr. Horn.
Good morning.
My client, actually, her dad died, and when they went to sell the house, they could not find the original trust. They had a copy of it, but the attorney told them that he could not proceed with a copy, that they had to have the original.
No, a copy is good enough.
Okay.
So, Angela, you reach out to your best friend at the title recorder, the title company you're using, okay? The title company is the gatekeeper. You show them the trust, and if they give you the green light that they will ensure good title to the buyer, then you're good to go.
Okay. Okay, great. Thank you.
Show it to the title company.
Okay.
All right, so let us continue. Yeah, that's perfect, Angela. If you have a question, just raise your hand and I will come and unmute you. All right, let us continue. So the moral of the story, keep a copy of your trust. If you don't have it, too bad, so sad. Okay, welcome to probate. Okay. Next. And so that's why when you go get your trust done, the lawyer will normally give you an electronic copy as well too. Okay, so for example, the trust that we do, you would normally get the original set, the binder, original paper, plus electronic copy. Okay, it'll be like I have to be in a USB setting like this. Okay, all right. Okay, let us move forward. So now when your client or yourself go and draft an estate planning document, you're going to get the trust. The house gets deeded to the trust. The trust owns the house. And the trust is going to say, hey, once I pass away, obviously I have 4 children. It's going to be divided by 4. But I choose Sarah, my oldest daughter, to be the successor trustee. Oh, by the way, if any of my children get a divorce, their spouse cannot touch it. It goes to my grandchildren. That should be the hallmark of a good trust. Okay. And then a good trust will also, let's say, for example, if you pass away and your spouse gets remarried, your trust should be able to protect against the new wife or the new husband. All right. So that should be in your trust. Now, the durable power of attorney, very, very important. So far, we've been talking about, hey, if someone passed away and they have a trust, this is what you do. A lot of time, and guys, I don't think you're beginning to see a lot of baby boomer passing away, okay? But also, before they pass away, they could be incapacitated, AKA dementia, Alzheimer's. And so let's say you have a client, dementia, husband has dementia, Alzheimer's, he's incapacitated. This house is way too big for them. The wife wants you to sell it. So the wife signs your listing agreement, but the husband's unable to, right? Because he's incapacitated. He doesn't know what he's signing. He thinks it's a birthday card. Your listing agreement is a birthday card. He can't sign. In that situation, you want to see if the husband had a durable power of attorney drafted. The durable power of attorney would say, hey, if I'm incapacitated, my wife, my daughter, my son can sign my name. So a durable power of attorney will come in very handy in that situation when you have a seller who's incapacitated, but prior to being incapacitated, in his sound mind, sign a legal documentation known as the durable power of attorney, giving the legal authority to someone he trusts to sign his name, to sign your listing agreement. That's called a durable power of attorney, okay? So that's why this list that I have here, guys, this list is a very important list. Take out your Kodak phone, take a picture of it. It's a Kodak moment. This is, in that same binder I show you, normally the estate planning binder, it's gonna have all these documents, okay? The Advanced Healthcare Directive, number 3, if you're in a hospital, you cannot speak or talk. The Advanced Healthcare Directive is a legal documentation that allows someone to speak on your behalf. And then also, we'll give you a pour-over will, as you see on the screen, a pour-over will. That just says, hey, if from time to time, guys, you go draft your trust, you get your trust done, and the lawyer deeded the house to the trust, but you refinance that house and the house came out of the trust. You refinance it, the house is out of the trust. So you die, there's a trust, but the house is under your name. Well, if you have a pour-over will, that's part of your estate planning, you can avoid a probate because the pour-over will pours the house into the trust to avoid a probate. It's known as a pour-over will, aka Hextech petition, to avoid a probate. Okay, so keep that in mind. In a situation where there's a trust, but the house is not in the trust, if the trust is properly drafted, we're able to do a Hextech petition if there's a pour-over will. All right, let's move forward. So now let's when we talk about probate, we're talking about title clearing, right? Someone died, they own that house, and there's no trust. Okay, so let's touch base on joint tenant for a second. Okay, so with joint tenant, let's say mom and dad owns a house and they're joint tenant. Let's say dad died first. Mom becomes sole owner. How? By filing an affidavit death of a joint tenant. Okay, no probate needed upon the first death. But upon the second death, it's going to be a probate. So that's how joint tenant works. But I want to share with you a problem with joint tenant. Okay, with joint tenant in a blended family situation, you might have a problem. If it's a blended family, you buy a house in joint tenant, with your new husband or new wife, you might accidentally disinherit your son or daughter. How? Let's look at an example together. So let's say this. Let's say we have Jane. She's 80 years old. She's super wealthy. She is a high producer at Ocar. High producer, super wealthy. She buys a $5 million house under joint tenant with her new husband, Rico Suave. 25 days after the wedding, Jane passed away. Who inherits the mansion? Rico Suave. Now, Jane had a daughter from a prior marriage. The daughter gets nothing. The house all goes to her new husband. So be careful with joint tenant. Okay, so the next time you take title on the joint tenant, think twice. Why am I doing joint tenant? Especially in California. Let's say you have a rental property. So let's do an example together. In California, if you are a married couple, you can do joint tenant or community property right of survivorship. Those are the three ways you can take title if you are a married couple in California. So you might say, what's the best way to take title? Is it joint tenant? Is it community property? Or is it community property right of survivorship? What's the difference? Well, in California, here's the rule. We live in a community property state. So let's say husband and wife bought a house let's say bought a rental property for $100,000. 40 years later, husband died, the house worth $1 million. If the house is under joint tenant, there's only a half step up in basis. The capital gain is $450. But if it's held on a community property, that same house, zero capital gain. So let me recap. You have a rental property you bought a long, long time ago. If it's held on a community property, your husband died, your wife died, you sell it, there's no capital gain. But under joint tenant, there'll be capital gain. So which way you think is better if you are buying a house in California and the money truly is community property? What do you think is the better way to take title? Do the third column, community property right of survivorship. That's the one you want to do if you are a married couple and that house truly is community property funds. All right. Any questions so far? Raise your hand and I'll unmute you guys. Any questions so far? All right, Vivian. Hi, Vivian.
Hi, good morning.
Good
So
morning.
does tenants in common apply for, let's say, a mother and a daughter when the husband passes?
So let's say you and your daughter buy a house under tenant in common. Well, tell me more, Vivian. Like, why are you asking me this question? Are you trying to see if you're buying a house with your daughter, what's the best way to take title, Vivian? Is that the question?
So yes, so father and daughter and mother are on title, and dad passes, and so they rework the trust, right? Now that dad has passed. And so tenants in common, is that an option? Or is it just joint tenancy?
Okay. All right. So forget everything you just said. Here's what you should do.
Okay, thank you.
Here's what I should do. Mom and dad should get a trust, put the house in a trust. The trust says after we both die, the house goes to our daughter. And when she sells our house, there's no capital gain, no taxes. Vivian, that's how you should do it.
Okay.
So you and your husband own a house, put it into a trust. The trust says after we both die, it goes to our daughter. And when it goes to your daughter, and if she decides to sell it, there's no capital gain. That is the right way to do it, Vivian.
Got it.
Yeah, don't mess. Now, if you and I are investing in a house, we're investing in a house, we're purely investor, then we do tenant in common because let's say if you die, your 50% goes to your family. My 50% go to my family. Vivian.
Yes.
That's the difference between tenant in commons and joint tenant.
Okay, but between family members, there's 3 people on title. Daughter, mother, father. Father dies.
Yeah, so then it goes to the other 2, daughter and mom. But why was the daughter on the grand deed in the first place?
They bought it all together.
Okay, yeah. So meaning that the daughter put some money into?
No, just the helped with the financing.
I see. Okay, yeah. But anyway, as a general rule of thumb, guys, put it into a trust so that when you die, the house go to your kid, then your kid gets a step up in basis. Okay. So
Okay.
as we move along in this webinar, there are certain times where I said, there are certain important points. Okay. And right now, the important point that I want to convey to you is something known as the step up in basis, what you see on the screen. So in real estate, if you own your house in a trust, meaning you still own this house, when you die, that's when your children gets this house, they get to step up in basis. Okay, it's a very powerful tax concept. Okay, so you should pull out your Kodak phone, maybe your iPhone would do. Okay, take a picture of this as a Kodak moment. So the example on the screen, you bought the house for 300,000 in Laguna Niguel. When you die, it's worth 3 million. If the house is in a trust, meaning you haven't meaning your son or daughter's name is not on the grand deed, she gets a step up basis. Her cost basis is 3 million. Okay, so this is a very important point to understand why you do not want your children to be on the grand deed while you are alive. Because if they're on the grand deed while you are alive, you don't get to step up in basis. Okay. Oh, let's see here. All right, any questions so far on the step up basis, guys? Raise your hand and I will unmute you. Let's see here. Hi, Scott. Scott? Scott Davis, are you able to?
Can you hear me?
Yes, I can.
Okay. Yeah, I don't know if you already covered this, but if let's say if you've got a husband and wife and one of them passes away, did that step up basis go to them immediately, or is that
Yes.
how
Yes.
does that work?
Yeah, if it's under community property. So meaning we look at the grand deed, Scott. We look at the
Okay.
grand deed. What does the grand deed show, Scott? Is it joint tenant or community property?
I'm just asking in general, because we have that come up a lot, with
Yeah.
1031. I'm in the 1031
Yeah,
business.
if it's under joint tenant, Scott, they only get a half step up in basis. If there's under community property vesting, then you get 100% step up in basis, Scott.
For the survivor?
Yes.
Okay.
So you and your wife bought a rental property for 100 grand.
Mm-hmm.
40 years later, you die. California law, husband always die first, Scott.
Right.
Just
Good.
kidding. Just kidding.
That's good to hear.
You and your husband bought a rental property for 100 grand. 40 years later, you die. And your wife goes and sell that house, that rental property for $1 million. There's no capital gain if you vested that house as community property.
Okay.
If you do joint tenant, there's going to be capital gain.
Okay.
So the takeaway,
Separate question. Do you say, for instance, my mom has a trust currently that she did several years ago with I think LegalZoom. Do you do like reviews of those trusts?
so the answer is, if it's um, the answer is yes, but I can always tell you, using LegalZoom is almost as good as a seller selling the house by themselves, not using an agent, Scott.
That's not good to hear.
It's trash.
How about can you help them if they're in, say, Las Vegas or Utah?
No, because when we get together in my office, or when it's done, I need them to sign the trust. I need them in my office in Cerritos.
Okay.
Yeah, so they probably, Scott, I highly recommend they go see an estate planning attorney in Las Vegas or Utah.
Okay.
Yeah.
Last question. If the trust has been formed in Utah, that's where it needs to be settled. That's where the probate court would happen and that type of thing.
Yes. Yeah, wherever the house is, whichever state the house is in, that state has the jurisdiction, the power over that house.
Okay. Thank you very much. Very, very awesome information. Thank you, Paul.
Good, good.
Appreciate it.
You are welcome. All right, let us move forward. Let's see. Oh, I think I see another hand up. Let's see here. I see, let's say hi to Gita. Hi, Gita. Hi, Gita. Gita, Amira. Can you unmute yourself, Gita? All right. Okay. So while that's happening, anybody else has a question so far? What we talked about, what we discussed? Raise your hand, and I'll come and unmute you. Hi, Gita.
Yes, I was just wondering, what's the benefit of joint tenancy then? Why they should have joint tenancy if in case somebody dies, then the wife has to have a capital gain?
People don't know any better. People don't know any better. Community property only happen in 8 states in the United States. California is one of them. Yeah. But yeah. So if you are a married couple, you just do community property or rather survivorship. That's the best way to. Let's say if your buyer is buying a house as a married couple, and the money is community property, then they should vest as community property rather than survivorship. The third column that you see there.
Yes.
Yeah. But let's say if a married couple is buying a house and that money is the wife's money from her mom, then you maybe just want it under her name only, for example.
Okay.
Yeah.
So it depends on the situation.
Yes, but for most married couple, they're gonna see that house belongs to both of them for a married couple. And if that's the case, you choose the third column, community property right survivorship. So when one spouse die, the other spouse can sell the property with no capital gain.
Yeah.
Yeah. Hi, Dave. Hey, Dave, can you hear me?
Yeah, can you hear me?
Yes, I can.
Okay, question. Have a trust, have half dozen rental properties. Can you and do you recommend putting each individual rental property into an LLC somehow affiliated with the trust?
So the answer is yes. The answer is yes, because an LLC gives you protection. Okay. So when we talk about protecting your real estate, there are different layers of defenses. The first best layer is the primary insurance. Make sure you have great primary insurance. The second layer is a secondary insurance known as the umbrella insurance. So let's say someone died in one of your rental property, they sue you for $3 million, they win. The primary insurance only covers up to $1 million, you're short $2 million. The umbrella, let's say it's a $5 million umbrella, would cover the remaining $2 million. So start off with the idea, have an umbrella, have a primary plus an umbrella. And then after that, if you want more protection, then put it into an LLC. And then the lawyer will draft something called an assignment that says, hey, whatever's in this LLC belongs to my trust. So that's how you connect the LLC with asset protection, passing it down to your children. Dave.
Thank you.
Yeah. And so that's why you see on the screen, I list all these components. These are the important components of what makes a good estate planning. The house, the bank account, LLCs, all that stuff goes into your trust. All right, let us move forward. So let's talk about, let's see here. All right, so now let's get into probate. So if a house is not in the trust, it's going to go to probate. Okay, so here's a very important screen for you to take a picture of. Okay, so now we're entering probate. Okay, so now you have pulled the grandee, and the grandee shows the house is in the name of the decedent, meaning there's no trust. So if there's no trust, it's going to go to a probate. Okay, all right. So probate, it takes a year long to do. It takes one whole year to do, at least a whole year. And it could be pretty expensive. So on the screen, there is a new law out starting April 1st of 2025 that says, hey, if it's the decedent primary resident and the value is $750,000 or less, then we still need the probate court, but instead of being a 1.5 year long process, it could be truncated into about 5 to 6 months. Well, say about 4 to 6 months. Okay. All right. So let's get into, this happens a lot, guys. A marriage name only. Do you ever see that happen out there? A lot. And what happened if the house is under that one spouse name and that spouse died, like the husband, for example? How would the house get passed to the wife? it needs to go to probate court, but we don't need to do a full-blown probate. We can do something called a spousal petition, what you see on the screen. Okay, so keep that in mind. The house is under the husband's name because he has good credit, for example. Okay, and when he passed away, that house needs to go to her somehow. Well, he needs to sign the grand deed to her, but he's dead. So we'll do what called a spousal petition to move it to the wife's name. Okay. Any question on this, guys? Raise your hand and I'll unmute you. All right, so let's see here. Let me unmute Mary. Hi, Mary.
Hello, thank you so much. So you're saying that you can submit a spousal petition even though the pour over will does state that everything goes to the trust?
Oh, okay. So in this situation, Mary, I'm talking about this couple have no estate planning at all.
Okay, all right.
Yeah,
Thank you.
if they have a trust, then we're gonna vote, then we don't need this. But a lot of time, Mary, a married couple, don't have a trust yet. The house is under the husband's name. The husband died. So how does the wife get the house, Mary? How? She can go to heaven and have the husband sign the grand deed to her. Do you think she can go to heaven somehow, Mary, and get the husband to sign the grand deed? Right? So no,
I
right?
understand. Yes.
Yeah, so she needs the judge to sign that house to her. And that process is not a probate process, it's called a spousal petition, Mary.
All right. Thank you so much.
You are welcome. Yeah, and that happens a lot, Mary. You will see it. You'll see it in your business that it's a married couple, husband has better credit, or wife has better credit, and it's under one name only. Okay, so that happens a lot. Okay. All right, so let's get into probate. Okay. So probate takes a year to complete. Okay, probate takes a year to complete. So what I want to show you is this chart. Oh, let's see here. Okay. So probate takes at least 1 year. And you can kind of visualize probate in three different phases. Each phase taking about 4 months. Phase 1 takes 4 months. Phase 2 takes another 4 months. Phase 3 takes another 4 months. The first phase, the first 4 months, is for the lawyer to do his thing, go to court, and get that son, that daughter approved as the personal representative. That's going to be the first 4 months. The second 4 months is where you can close escrow. So that's another major point. Probate takes a year and a half to complete, a year to complete, but you don't need to wait until the probate is completed for you to sell this house. You can sell the house while the probate is active. And you do that in the second phase. Okay, you do it in the second phase. Okay, yeah. So and the last 4 months is called the final accounting. So the takeaway is, guys, probate takes a whole year to do. I want you to understand that, oh, after 4 months, I should be able to sell this house. Why? Because it takes that long to get someone appointed to be the personal representative. So earlier we said, hey, if the house is in a trust, The successor trustee has the power to sign your listing agreement, right? But in a probate, it's going to be the personal representative. Okay. So let's do this. I'm going to bring up a chart. I'm going to bring up this chart right here. This is a very important chart. You guys should take a screenshot of this, what's on your screen. Mom died. There's no trust, no estate planning documentation. Okay. Mom has 4 children. So one of the 4 children is going to start the probate process, going to go to a probate attorney. That one child, whether it be the son or daughter, we call that person the petitioner. She's petitioning, hey, judge, my mom died. There's 4 of us. Hey, judge, I'm the petitioner. Appoint me as the personal representative. Do you see in the middle of the screen the phrase, the word personal representative? That is the person that's going to sign your listing agreement. Personal representative. It's a very important screen. Take a picture of this. Okay. All right. So the person who, the son or daughter who starts the probate is known as the petitioner. It takes 4 months to get him or her approved. Once he or she is approved, we call him or her the personal representative. If mom left a will, we call him or her the executor. If mom left no will, we call him or her the administrator. Okay, that's the vocabulary. All right. Okay, so now in a probate, there are certain things you need to understand in a probate. Okay, so the majority of probate, well, all probate, it's going to be either full authority or limited authority. Okay, take a picture of this. All probate cases, it's either going to be full authority or limited authority. About 90% of all probate cases are full authority on your left-hand side. The other 10% limited authority. If it's full authority, you can close escrow 5 months from the day the lawyer picks up the case. Okay. Remember how I said it takes 4 months, right? For the lawyer to get someone appointed, then the house can be sold if it's full authority. If it's limited authority, it's going to take like 10 months, 8 months, 11 months. It's very expensive with limited authority. So if you have a listing, always ask for full authority. Ask the lawyer to give you full authority. Ask the lawyer to process that case with full authority. Okay. On the screen are the legal form for probate real estate transaction. If it's full authority, after 4 months, you ask the lawyer for the letter, for the order for probate letters and notice of proposed action. Okay. If it's limited authority for you to close escrow, same thing. You're going to ask for order for probate letters. And then number 3, the order confirming sale of real property. Take a picture of this. This is huge. This is very, very important. Now, this is a little more detail. If it's full authority, take a picture of this. If you ever encounter, if you're the listing agent, if it's full authority, take a picture of this. This is what you're going to need to give escrow. All the documentation I show on the left-hand side of the screen. Okay. If it's limited authority, this is the screen right here. Very, very important. Okay, so what I want to do with you guys is this. I cover a lot of material. Okay. I cover a lot of material, but I want to give you something since you're on the webinar with me. I want to give you something. I have something. Oh, let me just show it to you. That's going to help you. I have something that I normally, it's an ebook, it's a library. I normally sell it for 99 bucks, $99, but I'm going to give it to you for free because you're on this webinar. Here's what you need to do. Okay. I normally sell it for 99, but since you're on the webinar, I'm going to give it to you for free. Here's what you need to do. Oh, here's what you need to do. I put the link. You click on that link. When you click on, you'll see the screen, and then you just say, oh, let me see here. What do? You click on, let's see here. Yeah, so what you do, you click on, I have a promo code. And so for example, you put in your name, and your email address, for example. And in the promo code, guys, it's gonna be OCAR, OCAR. If you use that code, you can bypass the $99 price. So it's a good deal, okay? So you fill out that page, you click on download the book, and then you go to your email. When you go to your email, you get a link. You get a link at your email. When you click on your email, there's a link. When you click on it, it'll take you to another page. And that's where you can download the ebook. And I also have very extensive, elaborated videos that's going to walk you through the probate process and everything that I taught with you, that I share with you today. So very important, okay? So if you wanted to kind of learn a little more about what I taught today, just do what I asked you to do. And it's going to give you a whole host of information. A library book, an ebook, that'll be worth your while, like a library for you to always to go back on. Okay. Yeah. And the promo code is OCAR, OCAR. That's the promo code. Okay. So what you do is you oh, let's see here. So you basically, let me kind of walk you through it again. Oh, let's see here. So yeah, so you just click on that ebook link. When you click on it, it will take you to this page right here. When you get to this page right here, you say, I have a promo code. You click on this promo code right here, you enter your information, and the promo code is OCAR. You check your email address. It'll give you another, and it'll take you there. It'll take you to a library where I have a bunch of videos and that ebook. Okay, it's very valuable. You should get it. Okay. All right. Any questions so far, guys? Scott Davis?
Yes, Paul. Can we, if we can download this slide deck that you've given us here, right?
No, the better download, the better one to go is everything that you need to know, Scott, everything you need to know.
Okay.
Is in a better format. It's in a better format here on the screen.
Oh, okay.
You can download my ebook. That's going to walk you through the whole entire process. And if you don't like to read, I have videos. Probate and Trust video part 1, part 2, part 3, very comprehensive. It breaks down the probate process, what happened in the first 3 months, what happened in the next 4 months, what happened in the next the 3 phases that I talked about. Yeah, so that's a better library. This is all you need in this topic. The next time you run across someone who passed away, you log onto my library and
Okay.
walk you through the whole entire process.
Paul, I have one other question, and I don't know if you already covered this again, but I'm actually in the 1030. I'm with First American in the 1031 exchange business, and I deal with tax code questions all day long. And one of the things I wanted to ask you, as far as the LLC goes, putting your investment property into an LLC, I've always heard, and you may have already covered this, but um, I've heard that the LLC doesn't protect you as much as most people think they do. I've heard they can come after you personally. Can you comment on that, or is that for another presentation?
Yeah. So LLC, Scott, has inside outside protection. Okay. So first of all, real estate, you always want to get a good primary insurance plus an umbrella, and then your third backup is the LLC. You have one rental property in that LLC. Someone die in that LLC, someone die in that rental property, they sue you for 5 million. You lose, they can only take what's inside that one LLC. They couldn't come after your house or your other rental property. So the LLC acts as a bomb shield. It contains all the damage in that one LLC only. Scott.
Okay.
Yeah.
Okay, good to know.
Yeah. All right, guys. So that's all I got for you guys today. If there's no more question, I will sign off. But very important, all you need to do, guys. I know I share a lot of information today. All you guys need to do is go to download the ebook, and that gives you access to the library. Do that, okay? And this is all I do, day in, day out, covering estate planning, probate. So you're getting the best information. I'm a specialist. I go to court every day. So it's not like I'm just reading books and sharing stuff and teaching you. I see it live in court every day. Okay. So download the ebook, view the videos, and you guys will be. This information is very important. The tsunami is coming where baby boomers are going to be passing away, and you're going to see a lot of transaction pertaining to exactly what I share with you today. Someone own a house, they pass away. This house needs to be sold. How do you do it? That's the content of this class. That's what we just went on. And the ebook and the video library you saw earlier leads you to all that. All right, guys. So what I'm gonna sign off. If there's no other question, I want to thank you all for attending this webinar. I want to thank OCAR, and I want to thank Elsie. Elsie is great. She's the one that coordinated all this. Thank you, Elsie. All right, guys. So take care, and we'll do this again soon. Bye, guys.